So I'm going to start off with the role of the school psychologist in CSE. School psychologists are a required member of a full CSE. They are not a required member of a sub-CSE unless we are reviewing a psych eval or considering placement in a more restricted setting. A school psychologist is permitted to fulfill the role of the chairperson at CSE. People could have more than one role on the CSE team. Some districts have school psychologists chair meetings. I used to chair a lot of meetings. The role of the school psychologist at the CSE. So they're there to interpret psychological or psychoeducational evaluation results. They're there to provide input about potential classifications and if a student meets criteria for classification. They can also provide input about potential diagnoses as appropriate. I'm going to talk more about that. They can assist with developing the students' present levels of performance with an emphasis on the social and management needs, but they can provide input on any of the areas for the present levels of performance. They can assist with they should assist with developing the goals with an emphasis on social emotional goals, but psychologists have a lot of training on how to write goals that are measurable and observable. And so even if it's not their domain, they can provide input about the measurability of a certain goal. And if it's observable and individualized to the student. And if they've done the educational testing of the student, they can use that testing to inform the academic goals. And then providing input in program services, supplementary aids, and strategies to assist the student with accessing the curriculum. They're a full member of the CSE just like anybody else. They have a unique perspective to add to the CSE based on their background. Under the IDEA, there are some evaluation requirements. An evaluation are the procedures that are used to determine whether a child has a disability and the nature and extent of the child's needs for special education and related services. An evaluation serves two purposes. It identifies students who need special education based on IDEA classification categories, and it also assists the team with identifying the special education and related services the student requires. And it's required that a CSE conducts a full and individual initial evaluation before classifying a student and developing an IEP for that student. There's nothing in the law about what needs to go into a psychological evaluation. A lot of people think that a psychological evaluation always has to include a cognitive and an achievement measure. That's not in the law. It might be best practice in nearly all circumstances to do that for an initial. It's helpful to get, in my opinion, and I'm old school when it comes to this kind of stuff, but I think it's helpful to get a measure of the student's cognitive ability to help us identify where they should be achieving and their strengths and weaknesses in their cognitive profile. And then also get an achievement measure so that we can see if they're achieving commensurate to their ability or not. Not just for learning disabilities, that can also help with other types of disabilities to identify if there's an academic impact that could warrant special education. But we need to look beyond just academic impact. So it used to be we would measure students' achievement, and if they were in the average range, we would say they don't qualify. But over the years, that standard has changed, so we have to see how the student is performing in all areas, their ability to develop and maintain appropriate relationships with peers and adults, their ability to be in school, to attend class, to be safe in school, lots of different things that we need to look at. A student could be achieving in the average range or even above the average range, but still need special education services if because of a disability in some other domain they have a need. So it's very important, even though the evaluation process doesn't require that we do certain assessments, we do have to assess in all areas of suspected disability. Okay, so a psych evaluation is typically a required component of an initial CSE evaluation, but it's not required when it's determined that a student doesn't have a need for that psychological evaluation. When the psychologist determines that it's not necessary as a component of that initial evaluation, they have to write a written report of the assessment, of their assessment that an evaluation is not needed, and a statement of the reasons that it's unnecessary, and that has to be reviewed by the committee. I don't like this. So I don't really want your psychologist to use this for initials. It is legally permissible, but I think it's a really bad idea. I think that the psychological evaluation is a crucial part of that initial evaluation. And so even though it's permissible, I don't recommend it. I've seen districts do this in situations where parents have submitted a private neuropsychological or psychological evaluation, and teams have said, well, that has everything we need. We don't have to conduct any additional testing. But the risk with doing it that way is it's very difficult to say that you disagree with any of the recommendations in that private evaluation if you have not conducted your own or gathered your own evaluative data. So if you're just going to rely on that private evaluation, you need, and if you don't agree with the recommendations, it's a good idea to have your own data. You would still consider that private eval, but you would also have your own data too.
What about CPSE? Just because sometimes we have students that's really articulation, and it's hard to get evaluations under the timeline now, and all of those other evaluations are a lot of times what holds the timeline up. So what about the psych there?
So I should have said at the outset, I'm not taking CPSE questions. I don't like them. They're hard. Listen, there could be a valid reason why you decide that a psych eval is not needed. If the reason for referral has nothing to do with anything other than articulation, and if you can't find a psychologist, maybe that's a reason to do it. You also have to live in the practical world that you live in. So there's a non-answer for you. But if that is available to you, if you think there's a reasonable reason to use it.
Who has the ultimate authority for determining whether it's needed or not?
Yeah, so good question. So the regs say the psychologist, and so I can see somebody once told me that every good psychologist is a little bit oppositional, and that was a very validating statement for me as a psychologist. Those who know me well can understand that. It does say the psychologist, but if the CSC chairperson decides that an evaluation is needed and we send home consent for it, then I think it's reasonable to say they have to do it. Other questions? All right, reevaluations. Reevals have to be conducted once every 3 years, not more than once a year unless the district and parent agree otherwise. When a student is due for reevaluation, what's supposed to happen is a group of individuals that includes the committee and others as appropriate determines if any additional data is needed as part of that. And the data is collected to determine a few things, whether the student still has a disability, whether the student's present levels of, to identify the student's present levels of performance, including abilities and needs, whether the student continues to need special education, and whether any additions or modifications to the services are needed for the student to meet the measurable annual goals and make progress in the continuum. So there is a process where we can identify that no additional evaluative data is needed and we don't need to do the reeval. I don't like that either. You're probably not surprised by that. If I were to, I'm always thinking worst case scenario, which is I have to defend the decisions you made at a due process hearing, and hopefully that will never happen for you, but it could. And if that happens, and if we don't have updated evaluative information, that makes it really hard for me to defend the decisions that we made. But with that said, there are all kinds of reasons that teams decide that a reevaluation isn't needed. We're short-staffed right now. It's hard to find people to do these. I understand that these are real-life issues that you're all facing. So a few tips. Even if you're not collecting additional evaluative data, I think it's helpful to do a records review and summarize that in a written report that can serve as that reevaluation. And I would ask for parent consent to do that because that's something additional we're doing, even though we're not doing direct testing with the student. And you can use that written report that summarizes the existing records as your next reevaluation date for the next 3 years. Because teams get confused. What do we do if we decide we don't need one? What do we do with that reeval date? The other thing is, you can be targeted with the testing that you do here. And I think it depends on a lot of factors. So if the student is in second grade, I think it's more important to do a full reevaluation. But if the student's in ninth grade, And if this kid has had 3 or 4 cognitive assessments, and we know this kid is average, we probably don't need to give him a cognitive assessment again. Maybe we are only assessing in the areas of need. The student has a learning disability, we're assessing in that area. If the student has social emotional needs, we're assessing in those areas. So we can use some clinical judgment around that. I think there's a few factors that matter. The student's age matters. The younger they are, the more important it is that we're doing those reevaluations every 3 years and that they're thorough, because things are changing so quickly when they're young. I've jumped into cases where kids are in 5th grade and haven't been evaluated since CPSE. And that's too long. They're a totally different kid. We don't even know what their abilities and needs are compared to CPSE. So the student's age matters, the student's needs matter, depending on the complexity of the student's needs. That should influence what we do. And if we do decide to skip a reevaluation year, maybe just do a records review, my recommendation is that we don't do that twice in a row. So the next time the student comes up for a reeval, we do a full reevaluation. But it is preferable, if you can, to do that reevaluation every 3 years. Questions about that? Oh, another tip for psychological evaluations. I strongly recommend that we don't put specific recommendations in a psych report. And I know that as psychologists, and I think everyone here knows I was a school psychologist, but I know as psychologists, we're trained to put tons of recommendations in reports. I used to have page after page after page in grad school of recommendations. But doing that in your report can cause a couple of problems. Number one, it can look a lot like predetermination, where a decision is made outside of CSC, depending, especially if you're very specific with classification and recommendations for program conservative. And number two, decisions about classification and recommendations are team decisions made by the whole CSC. And so I want psychologists to give their recommendations at the CSC meeting for the CSU to discuss. But I think it's risky to include those within the report. It puts the team in a tough position if they decide to go in a different direction. And it's not just up to the psychologist alone to make that decision. And I say that with respect. I've had a lot of psychologists push back on me with this. One time I had a group of psychologists show me California law, saying they had to do it. In New York State, there is no legal obligation to put recommendations in a report, and I don't recommend that you do it. And what you can say is something like, all recommendations will be made at CSC. So I do think your recommendations are important and valuable, but the time to share those is at CSC. Section 504 evaluations. The rules around Section 504 are in general less specific than the rules for CSC. And there is a requirement to conduct evaluations through Section 504. And this is something that a lot of teams don't realize. But there's more flexibility in Section 504 in deciding what evaluations and what areas you're going to assess than what you have at CSC. For Section 504, you truly only need to conduct an evaluation in the area of suspected need. So if a student is referred to Section 504 for something like diabetes, and if all they need are medical accommodations, you probably don't need to do a full evaluation for that student, unless we have some kind of academic or other concerns for the student. But if the student is referred to Section 504 for something like ADHD or anxiety, the two big ones that we probably see the most, it's a good idea to conduct an evaluation to gather some data around the student's needs. But it doesn't have to be a full psychoeducational evaluation. It might. There might be some students who need that full psycho ed. It should be an individualized decision. It could be for a student with ADHD we don't have any achievement concerns with them. Maybe that evaluation would be an observation, consultation with the parents and the teachers, a clinical interview with the student, and then some rating scales that maybe the parents, teachers, and student fill out. I've had psychologists ask why we're doing rating scales if we know a student already has a diagnosis. And the reason for that is because it gives us a standardized measure of how the student is performing compared to other students their same age. It allows us to identify if we're seeing symptoms related to that ADHD in different settings, in the school setting compared to the home setting. And that can help us determine if the student has a physical or mental impairment that substantially limits a major life activity. Because if it does, the student is entitled to a 504. There's no requirement, just FYI, I try to get this in whenever I can. There's no requirement for a diagnosis to be eligible for a 504. And a diagnosis doesn't automatically entitle you to a 504. The same is true for CSE. There's no requirement for a diagnosis to be classified in CSE for any of the classifications. The CSE might think a diagnosis is helpful, and if so, we can pursue getting that diagnosis. I used to like to see if the diagnosis was underlying for potential emotional disability, but it's not legally required. FBAs and BICs, we all know what those are. An FBA helps us identify if there are behaviors that are interfering with the student's ability to perform in school. And the BIC is the document that's created to address that. Psychologists can take the lead for conducting an FBA, developing a BIC. They typically have training around that. They're able to do that. But there's nothing in the regs that say it has to be a psychologist. So it can be really anybody who has expertise in this area. I think a psychologist is helpful to be on the team. And I also think that FBAs and BICs go better when it's a team working together rather than one person doing it on their own. I said earlier I was going to talk a little bit about school psychologists and diagnoses. So under the education law for the practice of psychology, it says that the only people who can engage in certain diagnoses are licensed psychologists. But then there's an exception to that that says a certified school psychologist who's practicing within the school setting can engage in all of the same tasks that a licensed psychologist can engage in. So that means a certified school psychologist in a school setting can legally provide a diagnosis for a student as part of their evaluation. That's something that school psychologists are frequently confused about. I hear regularly at CSE, I can't legally give a diagnosis. That's not accurate. I'm not saying that school psychologists should be diagnosing everybody. That's not what I'm saying. But school psychologists working in the school setting can perform the same functions as a licensed psychologist. And although we don't need a diagnosis to get to classification or 504 eligibility, there are situations where it might be helpful if our school psychologists are using their evaluations to determine if there's an underlying diagnosis. So some thoughts around that. Practical considerations. There's some diagnoses that are more likely to arise in this evaluation than others. So things like specific learning disabilities, dysgraphia, dyslexia, dyscalculia, and then anxiety, ADHD could be out there too, autism. So some districts, not many, some districts are training and supporting their school psychologists and being clinically sufficient in diagnosing certain diagnoses, like maybe anxiety and ADHD, because those come up so much. Because if we feel, let me back up. If we think that a diagnosis is important, we can't require the parent to go out and get that diagnosis. I used to say things to parents like, well, your kid might be eligible, but we don't have a diagnosis, so we can't find them eligible. That was not legal for me to say that. The reason for that is because we have to provide a free, appropriate public education, and requiring parents to go out and get us a diagnosis is not free to them. And we also have a child find obligation to identify, locate, and evaluate students with suspected disabilities. So we can't place that requirement on a parent to get us a diagnosis. If they share it with us on their own, great, we can use that, and we should consider that, but we can't require it. And if the team really thinks that a diagnosis is important, again, not required, but if we prefer to have it, it's on us to get that diagnosis if the parents haven't shared it on their own. So if our psychologists aren't in a position where they can diagnose, where they don't have the tools and the training to do it, we have to go bring somebody else in, a psychiatrist or somebody else coming in to do that. So there's some positives to having the psychologist be trained and competent in this area. But to do that, they have to have the competency and they have to have the tools, the assessment tools to be able to do it. And those are, you can't do it without that. And different psychologists have different competencies. We can't assume that they all have the same competency.
I was just going to say, maybe also on the educational diagnoses for designations versus the medical on things like autism too.
I lost my thing. Oh. But if they don't have the competencies, we can give them training and supervision to help them get there. The decision of whether we're going to have our psychologists do this really should be made by district administration in coordination and consultation with the psychologist. Most districts are not doing this. Some are. I'm a licensed psychologist and my district wouldn't let me diagnose. I used to say I could open an office across the street and diagnose everybody. And they said, we're not going to have you do that. That was their decision. That was fine. They let us work with a psychiatrist if we thought that a student might have a diagnosis that warranted, that was important. What Kate was saying was a good point. So when we're considering if a student is eligible for classification, it's not based on diagnosis. It's based on if they meet the definitional criteria in one of the 13 special education classifications. So if we're looking at autism, they only have to meet that criteria for the autism classification. They do not need a medical diagnosis for autism. If we're looking at ED, they only need to meet that criteria in ED, which is just having one of 5 potential symptoms. They don't need a diagnosis, but teams sometimes think a diagnosis will be helpful. I like to see if there was a diagnosis for ED. That was my clinical preference, not legally required. Manifestation determination reviews. So we know that there's certain circumstances where we have to conduct a manifestation determination if a student's going to be suspended for more than 10 days in a row or for more than a total of 10 days in the school year cumulatively, and this most recent reason constitutes a pattern. And then we're determining at manifestation whether the misconduct was caused by or directly and substantially related to the student's disability or a direct result of the failure to implement the student's IEP, which would include a BIC. A psychologist is not a mandated member of the manifestation team. If you read the regs in Part 201, it's pretty brief. It says basically a chairperson, the parent, and then people who are knowledgeable about the student. But I think psychologists are crucial members of manifestations. And it's important that the psychologist is aware of the student's disability-related needs before going into manifestation. So I have sat in on manifestations where the psychologist said, I've never met this student, I haven't read anything about them, I can't opine about the student, but I can talk generally about their diagnosis. That's not good enough. That's not the role of the psychologist. And when we're looking at manifestation, we're not really talking about diagnosis. We're talking about how have we identified this child's disability-related needs in their IEP, their evaluations, their BIP, their FBA. So a child with ADHD, the question is not, could ADHD cause this? It's, have we identified this child's ADHD-related needs as including symptoms or behaviors that are similar to this misconduct? All right, a little bit about school counseling. So right now in New York, there is no privileged relationship between a school counselor and a student. And this is something that school counselors, and this includes any counselor, a school counselor, a social worker, a psychologist, anybody who's providing school counseling, they don't have a privileged relationship with that student. And the reason for that is because the student is not employing them, they're employed by the district. And that means that communications that are provided to the school psychologist, social worker, counselor are not privileged, which means that parents are entitled to know them under most circumstances under FERPA if they ask. And there's been some decisions on this. These are both commissioner's appeals. This first one said no decision of the courts or the commissioner of education has yet granted privileged status to communications between a student and school personnel. And in this other one, this was where a student told their school counselor that they were under the influence of alcohol, and the school counselor reported it, and the student was disciplines for that. And the parent said, well, the counselor wasn't allowed to say that because that was privileged. And the commissioner said, actually, it wasn't. The students' communications were not protected by privilege. So there's not a privileged relationship. I'll have situations where we have true concerns about a student, and the administrator will ask the counselor, have they said anything to you about this? Maybe concerns about threats to others or threats to self. And counselors will say, well, I can't tell you that. That's not true. The school administrator would have a legitimate educational interest under FERPA in knowing that information. I'm not saying that school counselors should go out and report everything to everybody. That would not be appropriate. There's still confidentiality, but individuals who have that legitimate educational interest within the school are entitled to know if they need to know, and parents under FERPA are entitled to know if they ask. And that's important to share with students when we're entering into a counseling relationship, or if it looks like they're going to be sharing something particularly sensitive with us, to remind them of that.
What is your response to a counselor or psychologist when they tell you, I've heard this a lot, ethically though, in order to retain our license, ethically, it's not legally privileged, but ethically, we cannot disclose it.
Yeah, well, that's not good. So the law, we know, yeah. The law trumps ethics, and you're not going to lose your license because of ethics. People are so worried about losing their license. Does anybody here know anybody who's lost a license? Anybody? I don't. Right? It doesn't happen. Actually, I do. I know people who are doing really terrible things to kids who lost their license. That's the level of what you have to do to lose your license. And people don't seem to get that. And people don't see, and I understand their concern. They don't understand. I don't want to sound judgmental. And also, you're working for a school. That's your employer. You're in a public school district. If you don't like those rules, then go into private practice, because different rules apply there. But in a school, it's different. I also think that training programs are not doing a good job with teaching their students about this kind of thing. So there's a lot of misunderstandings. We see it with school nurses too. School nurses think that HIPAA applies and that they can't share medical records with people who have a legitimate educational interest in the school. That's not true. HIPAA has a carve out that says it doesn't apply in the school setting. It's FERPA that applies even to medical records in the school setting. So a lot of misunderstandings around that. Typically, counseling notes would be an education record under FERPA, which means that the parent asks to see them. They're entitled to, because they're entitled to review records. The only exception to that is if it's a sole possession record, which means that it's kept in the sole possession of the maker, used only as a personal memory aid, and not accessible or revealed to any other person except maybe a substitute. So when I was keeping counseling records of my students, I wrote them with the understanding that it was an educational record and parents could see them if they wanted to. And if there were situations where maybe something weird came up or something that was particularly sensitive, that really wasn't relevant to the work I was doing as far as IEP goals or something like that, I would jot that down in a different file that would be my sole possession record. But for the most part, my counseling notes on purpose, I wanted to be education records because I wanted the next psychologist to have access to them so they could continue to work. And I also think just generally it's a good idea to document, to be open about that documentation. If you're keeping your counseling notes as your IEP goal data, you can't say it's a sole possession record.
And we have a question from one of our Zoom attendees. It deals with diagnosis. Do we need parental consent to give a diagnosis?
Yeah, that's a really good question. I don't know. I've looked into that. I think there's an argument. I can see it being a problem if we don't say anything in our consent form that it could include diagnosis, and then we show up at CSE and we're like, your child has autism. I can see a parent being unhappy with that and having a valid claim about that they did not give informed consent for a diagnosis. So I think it's probably a good idea to say in consent that it could potentially include diagnosis. Most of you aren't doing diagnoses, so you don't have to worry about it. But if that could be an outcome, I think it's a good idea to include it in the consent form. Do you have any thoughts about that, Jeff?
Well, so I think there's two questions. The first question is, do you need consent? Do you need to do an consent to evaluate the diagnosis? That's one. The next question is, do you need to expressly put in the consent form, yes, I'll be diagnosed? That's so that's the level one.
Right.
I think you can argue either way. If some, so it's a tough one. Someone will find out the answer. So you take this, you probably want to put it expressly in.
Well, I can't find any law or guidance on it. I have researched this issue. So to be safe, it's better to put that in. But yeah, I can make an argument either way.
And then so if we, from a practical standpoint, if we list the consent form, we're going to do psychological counseling, we're going to do this, and we're going to do a diagnosis. And the parent crosses out the diagnosis, they can't do that. It's all or nothing, right? Now usually it's like for a partial consent, but technically, parent, you can take the position that's strong and say, when the district sends the consent form, the parent can't do a partial consent. It's everything or nothing. So.
I'm sorry. I was going to add into what Jeff was stating that typically the rule is that a parent cannot pick and choose aspects of the psychoeducational eval, but what I've typically advised there is that if the restrictions can be honored and still complete the evaluation with fidelity and get useful information, then that's something that you would proceed with, right? But Jeff makes a good point. If a parent's restrictions on how the district is being directed to do the evaluation effectively tie the district's hands, so you cannot get accurate evaluative information, then that is like a partial consent situation that you would not have to honor.
All right, we went on a journey with that. Okay, so the answer is we don't know. Probably a good idea. We could argue either way. That's the answer. Okay, there is a regulation in New York State that requires us to disclose information to parents under certain circumstances. Now, for everything I've talked to up to now, it's where we have to disclose if the parent asks us, right? We don't have to call the parent after every counseling session and say, here's what they said today. But if the parent asks us about how it's going, then we're supposed to disclose using some judgment about how we do that, of course, right? What's necessary to tell them. But there is a regulation that we're required to tell parents in writing when any aspect of the total school health program indicates that such student has defective sight or hearing or a physical disability or other condition which may require professional attention with regard to health. This could come up a lot in counseling. And there's some case law out there that has interpreted the rule to mean that New York law obligates a school to inform parents of conditions that affect health, safety, and welfare of children, and said that maybe that could include having to inform parents of student pregnancy, for example. That's what that particular case is about. But as judges typically do, because they're also lawyers, they didn't come out and say yes or no. They said maybe a student's pregnancy status needs to be disclosed under this regulation. If you have some districts have a policy, most don't anymore. If you have a policy on that, that would control. This was about a district policy that required disclosing to parents, and the teachers initiated litigation against the district for that. We should work with the kids, depending on how serious of a situation it is, to try to help the kid feel safe telling the parent themselves, or we help the child tell the parent, or if it really gets to the point, we need to tell the parent without the child, but we should work with the student if we can. If it's an emergency situation, we can't do that. But if we have time, we should try to let the parent know. If the child discloses us that they're pregnant, unless it's an emergency in that moment, we shouldn't call the parent and say, guess what? That does not protect the counseling relationship. But we should know that likely we need to find a way to let the parent know. In other situations, this comes up too. The last thing I'm going to say, psychologists should not be conducting psychological evaluations outside of CSE or 504. Nobody should be conducting any evaluations outside of CSE or 504. speech therapists, OTs, nobody. We should not be doing full evaluations outside of those two settings. I know that it's still happening and where districts are conducting evaluations as part of their RTI and RTSF process and using that information to decide if a student needs to be referred. And that's not allowed. You're violating your child find obligation by doing that. But maybe even more importantly, you're making CSE decisions outside of CSE about parents there. And so if we have enough of a suspicion that a student might have a disability, refer them to CSE. Literally, the only extra thing you have to do is have a CSE meeting. Even if you find a student ineligible, you have taken care of your child find obligations by doing that. And I've had teams say, oh, so many meetings. Well, maybe you're doing too many evals then. You know, we have to really think about if the student really needs an eval. But I know it's a lot of meetings, but it's worth it to have that extra meeting to do it the right way and to do it through CSE. Question?
I'm just wondering about screening tools.
So screenings, it depends for screenings. Anytime we're doing any assessment of a student that's not part of the regular curriculum, we need parent consent to do that. I think it's fine to do screenings with parent consent if it's not a universal screener for the RTI process, but we need to think about the tools that we're using for that. So generally, people can make arguments in the opposite of what I'm about to say. Standardized assessments aren't really screeners, generally. And the reason for that is because we're using a screener to collect baseline data to inform intervention. So yeah, I love the idea of collecting that baseline data, helping you identify goals, so that you can continue collecting data to see progress toward that goal. But if it looks like a formal evaluation, I would argue that's not a screener.
And question. But don't do evals out of the 504 process. Susie. What if a parent just says, hey, my son is so smart, he just needs some IQ testing so he can get into this gifted program. What do you do there?
Yeah, same answer. So we would tell parents, we have pediatricians ask us to do testing. We want to work with people. I get that, but it's okay, and it's the legally correct response to say we can't do an evaluation outside of CSE or 504. If you want to refer your child to one of those entities, you can. Or if they're bringing us information that triggers our child find, like if they say my child's been diagnosed with ADHD, I think they might need more, we should probably process that as a referral. But we don't do gifted evaluations. If a parent's smart, they'll refer them to CSE and they'll probably get that information. In Pennsylvania, we did gifted evals. And I've had parents cry harder that their child is not gifted than I've had when I've said their child has an intellectual disability. So that was fun to do and also really stressful.
Hey, one quick follow-up, so what happens when, as a courtesy to one person, to do that gifted IQ that?
Yeah, so,
And then what happens if next week someone asks to do the same thing?
so, and that comes up in other contexts. So we get questions about doing evaluations or writing notes for students to get certain assistive technology from their insurance. Or we get questions about writing a letter for guardianship purposes when a student turns 18. There's all kinds of reasons that parents are asking us to share information or to collect data for them. And I understand that we want to do it because we want to be cooperative, but that falls outside the scope of our role as school providers. And when you start saying yes to some, it's hard to draw that line and say no to others.
Recently, we've been getting some calls from networks, either URMC or Rochester Regional, and parents are having behavioral concerns at home while achieving in schools. We're not having the behavioral concerns, but we're being told that they need a full psychoeducational evaluation done by the school, but we're not seeing those concerns, but they won't move forward with the intake for that child. So we have to do it.
Well, no, you don't ever have to do an eval unless it's through CSE. But physicians can request a CSE referral, and there are procedures and the rights for what we're supposed to do when a CSE referral is requested, which includes talking with the parent to tell them that this referral is made and letting them know their right to initiate their own referral. And if the parent refers to CSE, then we have to process that. What if a parent requests a specific standardized assessment? Great question from a school psychologist. Okay, so if a parent requests, we have no obligation to give parents specific assessments. When I used to do the gifted evals, they would study with the kids and be like, you have to give them the WISC. And then I would not give them the WISC, right? Because in New York City, they have like organizations that you can hire to help your kid study for gifted evals. So we are not required to do the specific assessments that parents have asked for. We are required to assess in the areas of concern. So if a parent says, I want to take a woodcock, we should say, well, tell me more about that. What are your areas of concern? Is there anything about the woodcock that you think measures your areas of concern? And use that to figure out if you're going to use the woodcock or something else that measures those same areas. Okay, last question, I might do one.
I was just curious how various districts are navigating OPWD requests for evaluation, especially when we're so thin on finishing our initials or re-evals right now.
Yeah, so when I used to do my pre-evals, if I knew a kid might be eligible for OPWD, I usually just did the testing they needed because we probably needed it too. It's usually like a full cognitive and adaptive. And if that's a question, you should probably be doing that anyway. So your psychologist can lump that into their evaluations if it's also data that we need, but we have no obligation to do it in addition to our typical evals. Okay, we're going to talk about the 22 things.
Yeah, all right, yeah, we'll play. Yeah, good job, Aaron.
Why don't we take a 5-minute break or just swap out some?
Okay, Dave says that we're taking a 5-minute break to swap out some mics. So please hold tight for that.
Go ahead, Stephen.
It's it.
If you want to questions, we'll talk about this, right?
Yeah.
The runner to talk about it and while they're here.
Yeah. If we have
Exactly. Am I good to use this? Okay.
Ready? I'm trying to figure out. You're next, right? So I'm going to get you. Perfect world. Perfect world. Perfect world. How long? Like 10,
I can
15 minutes.
I can like move through it.
In a perfect world, like it's kind of we're done with you by 10:30. In a perfect world, we'll take a 10-minute break. We love to have, but no, but don't feel yours is good stuff though. Like yours is dead practical. Well, I was just talking to Tracy yesterday. She did. I mean, this is someone who she thought materials. She didn't know some of that stuff. You know, so.
Okay, Jeff. All right. Yeah, I'm ready. I know I've asked you 3,000 times.
Yeah, no, okay.
Thanks, Dave. I'm gonna say, look, you could say we're in doing it'd be a risk because because a parent can still initiate due process. If the district tried to appeal that up to the SRO, potentially the works. Yeah, given that we know SED's position will be.
I think if you want to take it, if it goes to a hearing in New York, SRO will go on. They'll have to be on a Second Circuit case. And
since there's a GED in New York till 22, under the same standard, they're gonna rule. We think it looks like, that so that's different. And that's the common law standard. That's why the regional associates shouldn't be applying common law. But it hasn't, they haven't ruled in New York, but they have to follow Second Circuit's analysis.
I think it's both good to go.
Like, we're on it.
Yeah. Yeah.
For that, or you have. You know what I mean? Like, difference between our regional and the actual.
Okay, yeah, I'm done. All right.
And I think it needs us.
Yeah.
All right, folks, we're gonna go ahead and get started with the next section. Good morning, everybody. So this next section of the presentation is going to be developments around when a student disability's eligibility for a FAPE ends. We've been referring to this as FAPE 22, which sounds a lot like some sort of sports play that you might call. So feel free to Blue 42, FAPE 22, use that however you would like to. All right, so we're going to just sort of set the stage, a little bit of background before we go into more detail. So in July of 2023, New York SED issued a memo advising school districts to provide special education programming and related services to students with disabilities through the age of 22. This memorandum was based on a Second Circuit Court decision. It was AR versus the Connecticut Board of Education, in which that court said that schools in Connecticut have to make a FAPE available to students with disabilities through the age of 22. This extended previous long-standing requirement in New York that students with disabilities are entitled to special education programs or services until they either receive the Regents or local high school diploma or the end of the school year in which they turn 21, whichever of those two occurs first. So
Through the year they turn 21, I thought it was changed the year they turn 22.
This is a long-standing requirement. Before all this, it was 21. That's the long-standing requirement.
So the Second Circuit decision, this was AR versus the Connecticut State Board of Education. The reason that we're talking about it today is because the Second Circuit has jurisdiction over Connecticut, New York, as well as Vermont. So the Connecticut requirements are similar to New York in that it requires students with disabilities to receive a FAPE until they earn a high school diploma or the end of the school year in which they turn 21. Connecticut provides public education to students without disabilities through the age of 22. And so the Second Circuit in this decision said, because you are providing that education to students without disabilities through the age of 22, it would be a denial of FAPE to not provide that same education to students with disabilities until those students are 22. Initially, this decision led to some uncertainty because now we have the Second Circuit decision that says 22, and we have the New York statutory law that says students with disabilities are eligible for a FAPE until the end of the school year in which they turn 21 or when they graduate, whichever occurs first. All right, so this was the formal opinion that was referenced on the first slide. So in response to the Second Circuit decision, I said, we're going to have questions. We understand that folks are confused. They issued this formal opinion and said that they fully embrace the Second Circuit decision that students with disabilities are entitled to a FAPE
through the end of the school year in which they turn 22. Their reasoning was that New York also provides publicly funding adult ed programs to students, to non-disabled students through 22, as Connecticut did. Therefore, NYSEG Council concluded that the following was regarding the interaction between federal and state law requires New York Public Schools to provide special ed and related services to resident students with disabilities at least until their 22nd birthday. Then in this memo, NYSEG goes a little bit further and says, while this wasn't specifically contemplated or addressed by the Second Circuit, we recommend, while not legally required, we recommend providing those services through the end of the school year in which the student turns 22. So they said, could have a situation where a student with a disability turns 22 at the very beginning of the school year. Their recommendation is that we provide services at the end of that school year.
This is called the happy birthday, here's the cake, there's the door. And so they didn't want that.
So then we have recent developments in New York State Court. So the first one is from March of 2024. This was a New York Albany County Supreme Court decision that ruled that the Second Circuit decision was contrary to New York education law. Because New York education law makes it very clear that students are eligible through the end of the school year in which they turn 21. But now we have the Second Circuit decision indicating that it might be through the end of the school year in which they turn 22. All right, so we sort of have this back and forth where a court rules and then SED says something and the court rules and then SED chimes in. So SED responds and issues a memo to school districts advising that their opinion of counsel from July of 2023 is still in effect and that students with disabilities shall continue to be eligible to receive a FAPE until their 22nd birthday.
Katie, just one quick thing just to highlight, because a lot of you aren't lawyers here. If you go back one slide, this decision, this is a New York State Supreme Court in Albany County. It's the lowest state court in New York. New York guys. Supreme Court on the bottom, Appellate Division, Court of Appeals. So that decision was for the lowest court in Albany County. And it's going up on appeal to the Appellate Division at some point. It's fine. This is for the non-order that.
All right, so in this further guidance from FED, Associate Commissioner Ferraro issued a Dear Parents of Students with Disabilities letter confirming SED's position that students with disabilities in New York are entitled to a FAPE until their 22nd birthday. And this letter was in part issued in response to reports that school districts are choosing to end special education services prior to a student turning 20. The letter further warned that school districts that refuse to follow the rule, if they're eligible until they're 22, will likely be liable for compensatory education. And then Commissioner Ferraro went into the issue is particularly concerning for students maybe waiting to start a program. We have in March of this year yet another Albany County Supreme Court. So as I was saying, this is the lowest New York State Court. This court differed a little bit from what the Albany Supreme Court did in 2024. And it said instead of saying whether it's a denial of FAPE or not, they really took up the issue of what authority does a New York Supreme Court have to enforce a Second Circuit decision? And it said that
Regional associate.
regional. Under this court's analysis, SED may only enforce New York education law, which, as we know, says that a student remains eligible for a FAPE until the end of the school year in which they turn 21. May not enforce the common law rule created by the Second Circuit. So the common law rule, this is what Jeff was referring to. This is judge-made law versus the statutory law that remains in effect in New York State. So the decision of Joint Custody lacked the right to enforce the Second Circuit's decision, but it didn't address the applicability of that ruling to impartial hearings. All right, takeaways, there's confusion among districts about how to proceed with this. You will know more, as Jack was saying, this is the Supreme Court decisions have been appealed, so we'll know more than those who have court's rule. The Second Circuit precedent continues to apply in New York. And even if New York appellate courts agree with the Mayapack decision this past March, and as a result, when I said cannot enforce the FAPE 22 rule, parents of students with disabilities in New York would still be able to demand enforcement of that FAPE 22 rule by initiating due process. Jeff, anything you want to add?
Right. Just a couple of things. This is such a bizarre issue. You're really in a school law and you're really in a legal world. This whole problem could have been avoided if we would have amended the education law to adopt the 22. We didn't. Or if we would have stopped the GED program in New York. We just hold it. But we really wanted to bring this up. There's been a lot of myths and misunderstandings. So some people are going to interpret this decision as FAPE 22 is over, and it's really not. And you're getting weird. And again, as legal, if you're like a legal geek, you love this stuff. But that Mayapack decision deals with SED ability to interpret common law, but most of the claims of hearings, they go to partial hearings, they review in the courts. And the thing is, again, nobody knows how a New York court would rule on this issue, but they have to follow the Second Circuit's analysis. New York's in the Second Circuit. They tipped us off the Connecticut decision, but that standard would apply. That standard says if the non-disabled kids can get a GED until they're 22, that will apply. So it's, if I were a betting man, I'd bet big in New York, they're going to have to adopt the FAPE 22. Until they do, anything's possible. But this certainly does not mean the end of FAPE 22. And so we really wanted to get that out there. And I think Katie, who's new to special ed, relatively been here for a couple of years, this is a very complex issue. So I applaud you for taking this on. You do the shortest straw. But you did a great job. And we really thought this is a very important issue. A lot of myths, a lot of misunderstandings. We even think some districts are stopping FAPE 22 what they're hearing. And you do that at your own peril.
In consideration of how complex this issue is, does Bond have a recommendation as far as doing the day of the 22nd birthday or continuing through the whole school year? I heard you mention the birthday party, but that's on the table.
Well, okay, great question. There's legal requirement. The legal requirement unequivocally stops. To the extent you want to go from the birthday to the end of the year, that's 100% courtesy, discretion. There's absolutely no legal requirement to do it. The only reason you do it is sort of out of sympathy, empathy. It seems cruel to end. And more districts than I thought are allowing the kids to stay. But they're not all doing it. There's no right or wrong answer, and it costs a lot of money. So if you're ending it at 22, you didn't break the law. You're following the law. Some going to the next winter break or spring break or the end of the month or end of the semester. But the legal answer is do not have to go. You don't have to go one day beyond the birthday. Any other questions?
Okay, that's my turn. Good morning. My name is Andrew Mark. I would practice with Jeff in the Buffalo office. I appreciate you having me here. I love coming back to Rochester. Went to Nazareth for undergrad. So the decision I'll have to make on my way home is what I'm going to it's a long time. But that's like a whole day's worth of food. So probably skip that. All right. So I'm here to talk about two possible pathways to an interim alternative educational setting, or what we refer to as the IAES. As Annie mentioned, this is becoming a hotter topic, at least for us out in the Buffalo way, and really because of the second pathway that we'll talk about, what shortages of placements. So we're having to strategize and talk about what alternatives do we have when we have a student who may not be appropriate and may even be dangerous. All right, so we'll just get right into it. So here's the first pathway. The first pathway, first way to placement in an IAES is by district personnel. All right, so under the regulations, a superintendent can place a student with a disability in an IAES in lieu of a suspension if one of these three conditions are met. So what do I mean in lieu of a suspension? So here's the world that we're living in. So we have a student who's engaged in misconduct. Superintendent's hearing is recommended. All right, we go through that phase, and so we're looking at a suspension in excess of 10 days, or in excess of 5 days. But if it's in excess of 10 days, then we have to go to manifestation. We find manifestation. All right, so we can't suspend the student, but we may be able to place the student in an IAES depending on what the misconduct is. So that's the world that we're in. Yeah. Sure.
I just want to jump in and clarify something, because those of you that are under oversight for the state are hearing that for disproportionality, are hearing them use the term IAES for reasons beyond these two reasons that Anne is presenting on right now. And the state is interpreting an IAES basically anytime a student is suspended or removed for disciplinary purposes. And that's really confusing. So an IAES, when you look at part 2 of one of the regs and read the definition, you can see why the state is saying it that way. I never thought of it that way before. So it's confusing. There's actually 3 ways that you use the term IAES that are totally different. One is how the state's using it broadly when kids are removed for their for discipline purposes. But the other 2 ways are what Andrew's talking about today. So.
Thank you. Okay, so as I said, so manifestation is found, can't suspend, but then there's another layer to that. Depending on the misconduct, we can ask for this. Most cases will be the hearing officer to recommend. In some cases, will be the superintendent actually presiding over the hearing. But in most cases, it'll be the hearing officer, and depending on the misconduct, we can ask for removal to an IAES. And here is the kind of misconduct. So if the student has inflicted serious bodily injury upon another person while at school, on school premises, at a school function, if the student was found to have carried or possessed a weapon at school, on school premises, or at a school function, or the student was found to have knowingly possessed or used illegal drugs or sold illegal drugs. So those are the 3 categories where we could potentially remove the student to an IAES: serious bodily injury, drugs, or weapons. Now, we'll talk about this, but there can be a factual dispute as to what is serious bodily injury. There can be factual disputes over what is a weapon. But we kind of talked about this already. This is just, again, to just kind of clarify where we are. This process is multi-layered, so we're connected to the 3214 world of the student discipline. So these are the overlapping procedures involved in disciplining a student with a disability. So we have superintendent's hearing, the MDR meeting, the penalty phase, and the CSD meeting to determine what that IAES would look like if that's what's ultimately recommended. So just to put a little bit more meat on the bone. So if it's determined, we all know this is kind of just quick review. If it's determined that the student is guilty at the superintendent's hearing, it needs to be determined if the suspension could exceed 10 days. So generally at the superintendent's hearing, they'll ask the district what if the student's found guilty, what penalty are we seeking? Usually it's if we're at a superintendent's hearing, it's a pretty serious violation of code conduct. So likely that we're going to be looking for 10 days. So if that's the case, then we have to go to a manifestation meeting and determine if there's a nexus between the misconduct and the disability. If no nexus is found, we return to the superintendent's hearing and we go to the penalty phase. Okay, we can be disciplined just like any other student. If a nexus is found, then the student must return to their educational placement. Can't suspend that student. Unless, but this is not a suspension, we say not so fast if it involves these three categories of conduct: serious bodily injury, a weapon, or illegal drugs. If one of those three conditions are met, then we can return. After the manifestation, we find no nexus. We go back to this. We go back to the superintendent's hearing. We can say we found manifestation, but this misconduct involves serious bodily injury. So we're going to ask the hearing officer to recommend an IAES. Okay, so that's this process and how it plays out. You have a question? Yeah. I feel like it's a natural with this thing.
So, I've done a few superintendent hearings, and here's the question we have. So that the state finds that there's a nexus and the student has to immediately return. It's day 4 of the 5-day suspension. Do they serve the 5th day or literally they immediately return that next day?
They return immediately.
Yeah. They don't not serve the short-term 5 days.
No.
Game over and exit.
Yeah. Okay, so just a little bit more color. So the IAES itself, the setting, if that is going to be ordered, that's going to be determined by the CSE. And what's the appropriate IAES for that student to be educated in. And it can only be up to 45 school days. That's the maximum amount of time. And actually, I think that was just falling.
See, I figure all the questions are coming here, so I'll stand here, but nope, I'm going back.
That just can't exceed the length of what you would suspend a student without a disability for whatever the misconduct is. So that's got to be a determination you make also. If you would only suspend the student for 40 days, you can't put them in an IAES for 45 days. Okay. Getting a little bit ahead of myself. Okay, so as I said, when you're going back to the hearing officer, if you found manifestation and involves serious bodily injury, they seriously hurt somebody, or they brought a knife to school, or they were found, they had possession of marijuana. Sometimes there will be a factual dispute as to whether or not what the student had, was it a weapon? Okay, if they hit somebody with something, or they threw something at somebody, but the parent is saying that's not a weapon. Are you crazy? But we think it's a weapon. So there might be an actual little mini hearing at the superintendent's hearing to decide what a weapon is, whether or not it's a weapon, or whether it was serious bodily injury. Okay, and when serious bodily injury has a definition, which, like most legal definitions, is not super helpful. So how do we figure out what constitutes serious bodily injury? We got to go back and we look at case law. All right, but let's start with the unhelpful definitions first, I guess. All right, so the regulations define serious bodily injury as bodily injury which involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member or mental faculty. That's pretty serious. It's in the name, serious bodily injury. So we're not talking about got slapped necessarily, okay? And we're talking about what the student has already done, not what they think they might do. And that's going to be in the second pathway, okay? What the student has done. What was the injury that occurred? All right, as I said, generally, this is considered a pretty high standard. And you'll see in the decision that we talk about, just might even raise your eyebrows a little bit to really get a sense of what it did, what counts, all right? Okay. All right, so here are some examples. I realized you can't see this. All right, I can see this. So this, if you can see it on your paper or the printout, maybe, but this is just a helpful graphic. This gives some examples. And I would say that some of these examples, I'll read them to you just so you can see, because I can see, I know you can. These are maybe what I guess would be more the obvious examples. So bodily injury involving substantial risk of death, a knife wound, of course, gunshot wound, internal bleeding, severe head trauma, other severe injuries that may pose a substantial risk of death. Thank you for that very circular example. Okay, so bodily injury involving extreme physical pain, broken bones, injuries to an individual's neck or spine, bite-related injuries in which the individual's skin was broken. We know that that happens. Injuries that cause large contusions or bruising, other injuries that cause extreme physical pain. Bodily injury involving protracted and obvious disfigurement, burn injuries, loss of a finger or limb, severe injuries to an individual's eyes, nose, or other facial features. Bodily injury involving protracted loss or impairment. This is the last category, so we're talking about maybe a concussion, a traumatic brain injury, causes long-term brain fog or difficulty concentrating. Okay, so we're not, coming back the next day and everything's fine. All right. Special ed connection. Yeah. So 9th grader. But this is obviously a non-exhaustive list. Okay, this doesn't cover every injury, every potential scenario under the sun. So there are going to be things that fall into this gray area. All right, not everything's as obvious as a gunshot wound or a knife wound. Okay, there's going to be cases where it's going to be a close call. Okay, so we'll have to you're going to have to convince the hearing officer, if you're seeking it on the basis of serious bodily injury, was this extreme pain? Okay, what evidence was there that this person experienced extreme pain? What evidence was there that this person experienced protracted loss of a limb or mental faculties? Okay, so we'll get into some case illustrations that I think help us understand this. Okay, so these are some examples where serious bodily injury was found. These are hearing officer decisions taken from kind of all over the country. So this first one, the administrator had extreme pain from a bite, punches, and kicks. They were treated at a medical center and prescribed muscle relaxants and pain relievers, required physical therapy to regain full range of motion in arms. Okay, so we're evidence that you had to be treated. Okay, and how long did the injury last will be a factor. Okay, now not every incident where you go, just because you go to see the school nurse after an incident doesn't mean that that's going to qualify as a substantial injury. Okay, second example, IHO found that a school counselor suffered protracted mental impairment. Person suffered a concussion. She described it as the worst headache of her life after being punched repeatedly by a student. Okay, so a concussion that lasts. Testimony is going to be helpful. What did this person experience? Did they scream while they were being hurt? Were they crying? Were they shaking afterwards? Did they have to be seen by EMT? Those are going to be factors that will help convince that hearing officer that this person was seriously injured. Okay. So the third bullet, bite in the A constituted serious bodily injury. The bite caused extreme pain, resulted in bleeding, permanent scarring. This is a really gross case. You can read it. I'm not going to say it. But yes, a bite that opens the skin can qualify, right? That we know that happens, unfortunately. Okay, and the last one, the student struck his paraprofessional, causing her to suffer severe concussion, including intense headaches, nausea, light sensitivity, lack of energy, difficulty focusing, and impaired thought processes. So this kind of substantial severe bodily injury can be, just mental. Okay, it doesn't necessarily have to result in them, but if you're having concussions, and you're suffering from, what would maybe look like post-traumatic stress, like ADHD and anxiety afterwards. All right, evidence of that can help meet that standard. All right, so here's an example where serious bodily injury was not found. All right, so during this incident, student choked the teacher. The other staff had to pry the student's hands away from the teacher's neck. Teacher suffered redness and abrasions to her hands and neck. Rated her pain 8 out of 10. Sounds pretty extreme. The swelling to her neck throat made talking painful. She also experienced limited range of motion in her neck that persisted for 2 weeks. I'm sorry, I said this is this is bodily injuries, not excuse me. Also suffered anxiety and depression from the incident. So that's a laundry list of things that are pretty serious. So, yeah, we have limited range of motion for 2 weeks. All right, notice the length of the injury that happened, and also suffered mental health effects. Now, I'm not saying that you need all of those things in every instance, okay? But coming back to school the next day, after taking over-the-counter medications, probably not going to convince a hearing officer that the person was substantially injured. Okay, so here's one of the examples. Bodily injury not found. So no serious bodily injury occurred where the teacher experienced redness, swelling, and pain, only missed a day of work. In Pittsburgh Public School District, 2016, no bodily injury found where the principal suffered a migraine after the student punched her in the head. Pain abated after she drove herself home, took medication, and lay down for 30 minutes. So that's, it was pretty much over in a couple of hours, not a substantial injury or serious bodily injury. And last one, no serious bodily injury where a teen hit an AIDS hand causing quote unquote injury. So that's what we call in the legal world a conclusory allegation. Okay, that you suffered an injury. Well, you have to give the hearing officer something to hang their hat on in terms of evidence. What was the injury? Okay, so was there, screaming? Was there crying? Things like that. Okay, how long did it last? Let's see. I think I just skipped my. Oh. Yes. Okay. So here are some of the factors that a hearing officer will consider, or that you see considered in the cases. So all of these situations are going to be fact dependent. Okay, it's going to depend on the unique circumstances of each case. So, what was the pain experience during and after the incident? So I've mentioned like how was the person reacting? You may have to have that person testify, or unless there's contemporaneous notes taken and introduce those. Okay, having that person talk about their experience and going through it. In some cases, maybe they won't need to. A photograph of the injury or something like that. But the psychological and cognitive impacts of the injuries are going to matter, and the extent of the medical treatment required. So there's that case where the person put Tylenol, that's not necessarily indicative of a serious bodily injury. But you're being treated for 2 weeks afterwards, not saying it always has to be 2 weeks, but something beyond a day. You're going to have a hard time convincing a hearing officer that you suffered a substantial injury if you were out of work for a couple hours. A question?
So this is the first time that we're moving about the psychological potential definition of it. Just playing this out. If there's a fight and the victim comes to the district unable to pull out of fear and sort of a long-lasting sense of safety, we get the diagnosis or a treatment note. Would that be something to take to indicate that this incident has led to psychological impact on the
Psychological impact on all of the other students fearful to come back? And I asked the answer.
That's a really good question. I think it's probably unlikely. What's really about serious bodily injury really is more focused on physical injuries. What's really important here is that in phase 1 of the hearing, that you make sure you get into evidence what that serious bodily injury is. Because when you go to the manifestation and you find the connection, and then you go back in phase 3 and tell the hearing officer, we found a connection, but we're asking for a recommendation for an IAES due to serious bodily injury. You already need that in the record to give the hearing officer that evidence that that was present. So it's ultimately, the hearing officer makes the recommendation, the superintendent makes the final decision, just like for anything. But did you come across any cases that said something like that?
No, but I think Ian's right. So when you look at the last category, it says bodily injury involving protracted loss of impairment. So I think, to me, there's a presumption that there's some sort of injury first, and it's not just, the injury is not, I witnessed it, and now I'm nervous to be back. So I would think that at a minimum, you would need a bodily injury. Yeah. That leads to that anxiety. Does that make sense? Okay. Moving along here. Okay, so you get to put on your black robe, okay, and you get to be the judge here. All right, so let's read through, I think this is fun. All right, second grader with ED and bipolar disorder kicked the principal's stomach and legs, bit her upper arm through her suit jacket. The principal's skin wasn't broken, but the area around the bite was sore and red. The principal's report, written just after the incident, did not mention pain, but she immediately visited the doctor, who diagnosed an arm contusion, hip, thigh, leg, and ankle abrasions. She got banged up. The doctor didn't prescribe pain medication or mention pain in the medical report, but the doctor gave the principal Tylenol as a precautionary measure. The next day, the district removed the student to an IES, asserting the principal endured extreme physical pain. So, what do you think? Is it going to stand? A lot of heads shaking no. Okay. You were correct. All right. The IHO found principal pain was not extreme, therefore did not sustain serious bodily injury. The IHO, noted that the pain medication wasn't prescribed. Pain wasn't even discussed in the medical report. The principal's report also didn't mention pain. Okay. So if you're doing it, sometimes it's not saying make it up, but if you think there may be a chance that you're going to go, that you may end up down this road. I mean, if injury was involved, make sure you're documenting in some way whether that was extreme physical pain, how it was extreme physical pain. We got to convince a hearing officer that this person was seriously injured, okay, and suffered extreme physical pain. What's extreme physical pain for me may not be extreme physical pain for you, but we want to paint that picture for the hearing officer. The doctor's decision to give the principal Tylenol also is a precautionary measure, kind of indicate the pain was less than extreme. I think that's fair. And so, accordingly, the IHO ordered the student's return. All right. So, if you got that right, congratulations. If you didn't, that's okay. Life goes on. All right. Okay. So, the next category of misconduct you can be placed in an IES is possessing a weapon. Okay. So, the regulations define a weapon as a weapon, device, instrument, material, substance, animate or inanimate that is used for or is readily capable of causing death or serious bodily injury. We just talked about what serious bodily injury is. Okay, those four categories: substantial risk of death, extreme physical pain, protracted obvious disfigurement. So if an object, inanimate or inanimate, that can be used for doing or is readily capable of doing one of those things, it can count as a weapon. Okay, we know it does not include a pocket knife with a blade of less than 2 1/2 inches. Okay, so that's expressly exempt. I'm not saying you won't get suspended for it, but it's crazy cool. But anyway, all right. So now an item does not have to be designed to inflict harm to qualify as a weapon. Okay, it does not have to be designed. Computers are not designed to inflict harm. Okay, a golf club is not designed to inflict harm, but in some instances, how that's used, it may be considered a weapon. Okay. Now, intent is also not dispositive. If you have a weapon, okay, let's say you come to school with a knife in your backpack that's blade is longer than 2 1/2 inches, it is not going to get you out of an IAES to say that I didn't mean to have it. Okay, intent is not dispositive. We're talking about possession here. Now, that's not the case when we talk about drugs. Okay, there is an intent requirement written into that one, but not so for weapons. Okay. All right, so here are some examples of what qualifies as a weapon and what doesn't qualify. So a firearm is defined by the Gun-Free Schools Act. I didn't include that whole definition here, but a firearm is what you think it is. Okay. Also includes things like explosives. A knife with a blade of 2 1/2 inches or longer. A BB gun has been found to be a weapon. A metal awl. I don't know, some of you may or may not know what a metal awl is. It's a slender little metal stick with a point at the end of it. Okay. So the hearing officer in that case said undoubtedly capable of injuring, including notably causing the loss or impairment of an eye if misused by the student. Scissors can be a weapon. So in this case, here's the context: the student lunged at a teacher with a pair of scissors. That use of the scissors constituted use of a weapon. In another case, the student picked them up and gestured threateningly towards staff. So that's an object not necessarily designed to inflict harm, but certainly can if used the wrong way. Okay, but here's an example where scissors were not considered a weapon. So in this case, a student with an emotional disturbance pointed a pair of scissors at a classmate in apparent fit of anger. The student used them in a threatening manner, but they were rounded tip scissors. Okay, the scissors had dull blades and rounded tips. They could only cut paper. So in that case, that situation, that case was decided that that's not a weapon. That's not going to cause substantial bodily, serious bodily injury or risk of death, substantial risk of death. Okay, so how again, the facts matter. What the exact circumstances are will matter. Okay. Also not considered to be a weapon in some cases. A paintball gun was not a weapon. Pencil was not a weapon. In that case, I remember correctly, the student was dysregulated and kind of swinging a pencil around. I think it accidentally hit somebody or accidentally stabbed somebody. But I mean, perhaps you could make an argument that if you're purposely pointing a pencil at somebody like a pair of scissors, or there's possibly an argument that it could be a weapon in that sense. Okay, so how the object is used will matter. The wrench is not a weapon. Now, in the hands of Colonel Mustard in the library, maybe it is a weapon. Okay, but in this case, it was in the bag. I think it was in a student's bag. It was not touched. Didn't bring it out. But again, if you're lunging at somebody with a wrench or a head, you got a different argument there. Okay, the plastic foam receiver, or we were talking about a kindergartner in this case. And in fact, the hearing officer said it's difficult to imagine any instance where a kindergarten student could cause death to anyone by throwing any of the objects at anyone at any range or velocity. Plastic foam receivers and thermostats, no matter how broken or jagged, are not readily capable of causing substantial risk of death. Okay, so we might, depends perhaps on the age of the student. Okay, and what were the objects and how are they using? So, swinging a plastic bat, a kindergartner may not be an injury. Okay, but high schoolers swinging a bat, different story. So, objects that are not inherently dangerous, we're going to look at how that object was used. What are the circumstances surrounding that? Okay, drugs and controlled substances. All right, that's the third category that we'll get. That you can ask for an IAEF for on the grounds up. So you can also be removed from an IAEF if they have knowingly possessed or used illegal drugs. So here is where the intent requirement is. We didn't have any intent requirement. Usually we don't have an intent standard in a code of conduct, but in this case, to properly remove to an IAEF for drugs, the standard is they have to knowingly possess it. So when you're asking for an IAEF on these grounds, you may have to prove that it was knowing possession. Now, at the superintendent's phase, you may not have to prove intent at all, because just having it in school is a violation of the code of conduct. But to remove from an IAES, probably a good idea to just prove it at the hearing if you have the proof. Okay, you'll have to show that this was knowing possession. You knew they had it. Okay. All right, and the other thing to note here is this is governed by federal law. Okay, an illegal drug is any drug that is not legally. Excuse me, I'm sorry. An illegal drug does not include a controlled substance that is legally possessed or used under the care of a health provider prescription drug. Okay, or possessed in compliance with federal law. So we know there's a difference between federal law and state law when it comes to marijuana. All right. Federal law governs here, okay? It doesn't matter that marijuana is legal in New York State. It's not legal under federal law, okay? So that qualifies as an illegal drug for purposes of the IDEA. Okay, so here are some of the examples. Marijuana, most cases, probably we're talking about that kind of drug, and that includes edibles, by the way. And these are some of the other less common ones, but I just threw these in here so you can be on the lookout for Robitussin AC. Which I never heard of today. Okay, so that covers the first pathway. So these are some additional considerations. So as I mentioned, the components of the IAES, even though the superintendent of schools can order the removal to the IAES on those grounds, the component of the IAES is determined by the CSE. While in the IAES, the student, if they're going down this road, you have to do an FBA. if one hasn't been done, and behavioral intervention services and modifications to address those behaviors. So if they already have a BIP, then we're looking at, do we need to modify this BIP? If they don't have a BIP, then we need to have one in place. As I mentioned, the IAES cannot exceed the period of time in which a non-disabled student will be suspended. Okay, and the maximum period of removal is 45 days.
Andrew, have a question?
Okay.
It's for me.
Okay.
Go ahead. So from a practical standpoint, we're at, you have the manifest, superintendent's hearing, fine nexus, you have to go back to the penalty phase. The hearing officer who's there says yes, it's allowed. And makes a determination, notifies the superintendent it needs to an IES. How do you document that? Like, what does the superintendent do at that point to put this in effect?
So we would ask, for the hearing officer to put that in a recommendation and report, then the superintendent would issue a letter to the families, basically adopting the hearing officer's recommendation and then ordering the IES. Doing anything else to add beyond that, or?
Right, well, you should say the letter to be determined by the CIO.
Okay.
Right, because the superintendent's always saying, I have no idea where the student should go for an IAES, and they shouldn't know, it's not their job. So the letter, which those are the most important, on the previous slide, must be determined by the CSC. Well, it has to say in the superintendent's letter, 45 school days to be determined by the CSC.
What if it's at the manifestation that has to happen because the principal suspension will take them over 10 days? So it never makes it to the superintendent then. So at that manifestation, a manifestation is found. It's one of, and does the superintendent then make the determination if it falls in one of these three categories? Because there's no hearing officer there yet.
Gotcha. Go ahead. Go ahead.
Well, remember, it has to be as long as the punishment. So if it's only at the principal stage, it would only be like 5 days. So you're probably not going to go through a whole IAES process for a 5-day or 3-day IAES. But you still, so let's say you're finding out there's a nexus on like day 2 before, so when does the superintendent's hearing take place?
So it wouldn't because so like say a kid did 8 days. This is what we have to put in place for the state. A kid's at 8 days, the principal wants to put them out for 5 and go to a hearing. Let's say they're at 10. Principal wants to put them out for 5 and go to a hearing. There's a pattern. So then they come to the manifestation to do the principal suspension. And we find a manifestation that we were told stops it from even going to a superintendent's hearing then because we found a manifestation. But if it fits one of those 3 categories there, who makes the determination then? Because there isn't a hearing officer.
You have to have a hearing. You have to have a hearing to determine how long the suspension would have been. Because you need that information to determine the length of the IAES. Because otherwise.
Yeah, I totally agree. I'll say that issue.
Yeah.
Great question. Thank you, John. All right, so the second pathway, and this is the one that I was talking about, is becoming, at least out in our area, this is placement by an IHO. All right, and this is a situation where the district is actually initiating an impartial hearing against the family or against the parent. Okay, we're initiating a legal proceeding. We want to have a hearing on whether or not the student should be removed. Now, this is kind of a nuclear option, and we didn't really consider this, at least not our way, for a while. And there are lots of reasons why. Just commencing a hearing against the family is not, the greatest position you want to be in. Sometimes we have no choice, but also it requires a board resolution. Maybe we don't want to have to go through that process. But I think probably more than just the headache of that is maybe just the souring of the relationship with the family. You know, we generally try to work things out, you know, resolve them, but we're not always able to do that. So we are in this process, we are outside of the student discipline context. Not saying it's not relevant, but in the first pathway, we are under 3214. We're going through the superintendent's hearing. We're talking about the student already committed certain acts. Now, in this situation, it's different. We're thinking about the likelihood that a student may cause injury to somebody, to himself, him or herself, or others. All right. So this is a regulation. The district may initiate an impartial hearing for the temporary placement of the student on IES on the ground that maintaining the student in their current placement is substantially likely to result to the student or others. It may not have yet, okay? But we're worried and concerned. You know, we're seeing escalating behavior, and we maybe need to get this student removed. Now, the reason I'm saying that we're seeing this option considered more and more now is because there's a shortage of placements. So sometimes we have to think strategically about whether or not this, you know, if we have a placement and the parent's not accepting it, you know, we've been in that situation before where, you know, keeping the student in school is just no longer an option. Can be for a number of different reasons. Maybe we're getting, you know, not saying that they're good reasons, sometimes they're not. Maybe we're getting extreme pushback from the teachers union, you know, that they're afraid to be around a particular student, you know, whether the reasons are good or bad. But there are just, you know, factors at work here that, you know, we can't put them in an outside placement, but we can't keep them here. So maybe this is something that we need to consider. And I mentioned there's no requirement to commence a disciplinary action against the student as a prerequisite. There's no prerequisite that they already, you know, engaged in certain misconduct. Now, if they haven't, or it's going to be harder to convince the hearing officer that they're maintaining them in their placement, it's going to cause injury to somebody. But it's not a legal prerequisite. And under these rules, the hearing is expedited. So if we do this, it's on an expedited basis. So 10 days to have a resolution session, 20 days to have the hearing. All right. Let's see. So one of the reasons this is being considered now too is there's an interesting aspect to this involving tenancy. So under the rules, when an expedited due process hearing has been requested because the district believes that maintaining the student is likely to result in injury, the regs say that the student shall remain in the IES pending the decision of the impartial hearing officer or until the expiration of the period of removal, whichever occurs first. So that's one reason why you may consider going down this road is because you have an automatic pendency placement in the IES. Now, one thing I should mention is like this is not the only pathway you can initiate a legal proceeding. It used to be only you could go to court and petition the court for the removal, but sometime maybe around 20 years ago they amended the state regulations and added this option in there. And funny enough, there's also typically there's an exhaustion requirement. You have to do what's called exhaust your administrative remedies before you go to court under the IDA. You have to have a hearing. You can't just go sue the district court. In this case, you still go to court if that's the path you want to choose and ask the court to remove a student to an IES. It would be on the same legal standard. They're substantially likely to cause injury. But as far as I'm aware, in this hearing process under the regs is how you get the automatic pendency removal to the IES. Right? So that's one reason you may want to have a discussion, does this make sense? Maybe we might lose, but at a minimum, maybe we get them out for 20 days. That could factor into your discussion. All right, so as I mentioned, the legal standard to prevail, you have to prove that maintaining the student and keeping the student in their current placement is substantially likely to result in injury to the student or others. So again, you have a legal definition that, you don't know what that means. What is substantially likely to result in injury to the student or others? It's not clearly defined. Does that mean substantially likely to result in serious bodily injury that we talked about before. That's not in the statute. That's not in the regulation. I mean, most of the decisions that I've read don't suggest that that's the standard, or it's not likely to cause serious bodily injury, just likely to cause injury. And I think we're aware that at least one regional associate has said that it's less than serious bodily injury as well. The point is that the hearing officers have, it's up to their judgment. Okay, so the evidence that you present is going to matter. So they have to consider all the factors in the body of evidence presented in, on each individualized case to determine whether that behavior is going to cause injury to the others. So it's fact specific. So, what's the hearing officer going to consider? Okay, what's the history of the student involved here? What have they done before? Has it just been limited to verbal threats? Has there been any kind of physical aggression? Is this getting worse? How long has it been since the last incident? So if you have a student, you've had some concerns, but it's been 6 months since the last anything, you're going to have a little bit more trouble, I think, convincing a hearing officer that having the student there is going to cause injury. Also, what has the district done to address it? Have we done an FDA? Have we done a bit? If you ask to remove a student because you think their behavior is going to cause injury to themselves or others, and that's the first ask, I think you're going to have an uphill climb most of the time. Okay, so here's an example where the standard was not met. Okay, we have a 17-year-old student with ADD, ADHD, ODD. He shoved the desk into the thighs of a substitute teacher, punched her wrist after she confronted him about wearing headphones. Interestingly, the substitute was not given a copy of the student's IEP, which indicated he had anger, and the IEP had, documented that he had anger management issues when he was confronted by authority. So there's one thing right there that might have avoided that entire situation. Okay, and the hearing officer picked up on that. So they it was found to be a manifestation, so they could be suspended, but the district said they were going to remove him on the basis that he was substantially likely to injure himself or others. The district's position was that this incident was a culmination of an escalating pattern of threatening, verbally abusive outbursts directed at school authorities. So they were saying that this is getting worse and worse and worse. Now, one incident occurred approximately 3 months later. He yelled profanities at a paraprofessional, "Shut the F up or I'll kill you." I mean, that sounds scary, right? That can be pretty scary. A 17-year-old yelling in your face that they're going to kill you, I think would be jarring for most people. In another incident, a month prior, the teacher confronted him about copying work, got real close to her face and called her the B word. Later during a discussion, slammed the door during a discussion about the incident with the principal. Okay, so those are aggressive behaviors, but are they enough to convince a hearing officer that this student is going to injure himself or others if he stays there? And according to the IHO, the answer was no. So the record did not support the incident with the culmination of a pattern. There was no mention of either of those two events in the progress reports or evaluations. No indication from the student's teachers who saw him on a daily basis that they were noticing an increase in anger or a shorter fuse or less predictability in his behaviors. And the IHO further found that the incident might have been preventable, as we said, if the district had provided the substitute a copy of the student's IEP. The whole situation could have been avoided. And interestingly, the district had not conducted an FBA of that student, and they in fact even refused to conduct an FBA outside of the context of an IAES. So a lot of things stacked against the district in that. The history was mostly limited to verbal aggression, not exclusively, but mostly. The last incident was 3 months prior, and they hadn't done an FBA to address some of those concerning behaviors. So it's going to be hard for your attorney to convince a hearing officer that that's the case, that that student should be taken out of their placement, under those facts. Now, here's an example where the standard was met, okay? Several behavioral incidents. This is El Segundo, California. Grabbed a backpack of another student, tried to hit others, shouting, "I'll kill you." Staff tried to intervene, and she lunged at them with fists swinging. balled her fist at an aide saying, "I'll kill you." She eloped when staff tried to intervene. In a couple-month period, the assistant principal had been punched, slapped, kicked, pushed by a student, been injured at least 5 times, and similar incidents occurred throughout the year. In this case, the district had made several unsuccessful attempts to address behavior, including conducting an FBA, developing a BIP, providing aid, and other supports. So what happened was, in this case, for the next year, the district recommended an outside placement. They finished that school year, all that was going on, and then in the next school year, they were recommending an outside placement. Parents refused it. So at the beginning of the school year, the district wanted to seek an order for placing that kid in an IAES. Funny enough, the student went all the way through that summer and attended without incident either. But in this case, the IHO ruled for the district, finding that it was abundantly clear the district was unable to address the student's need during the previous school year, despite that she attended ESY without incident. But there was also a lot more evidence in that case. And I think what tipped the scale for the district in that case was all the interventions that they had tried first. Now, not saying that you have to exhaust every single possible thing in every situation. Every situation is going to be different. But certain things are going to more likely work in your favor. So here are some important factors. If we look at the case law, these are the takeaways. So prior incidents of physical aggression doesn't always have to be present, but the absence of physical evidence of aggression is going to make attaining an order for an IAES much more difficult. Prior physical injuries, documentation that the student's behavior had resulted in injuries to students, peers, or staffs in the past may also be helpful. Again, not saying you have to wait until that happens. It's an uncomfortable situation to be in. Certainly if you're concerned, and I totally get it. But this is what the case law says. We're dealing with students with disabilities and they have rights. So these are generally speaking the factors and the evidence required to get a student removed. So evidence of behaviors increasing severity also will matter. So if you're seeing an escalating pattern, make sure you're documenting. Documents that show an increasingly more intense behavior or that shows that incidents are increasing in duration may also support that student saying school is likely to result in injury. Prior attempts to address behavior, as I mentioned, these are the things that you'll need to convince a hearing officer of. And remoteness in time is a factor, which I've already mentioned. The longer you go between incidents, the harder it is to convince a hearing officer that student with a disability needs to be removed from placement due to dangerousness. So again, additional considerations. As a general rule, the student's placement in this type of IES cannot exceed 45 school days. And interestingly, what's different about this versus the first pathway, as you're coming up to the end of the 45 days, there's a process for going and repeating these procedures to keep the student out. Okay, so you can ask for, you can do this over again. Essentially, if you still think the student is continuing to, or maintaining them in their placement is likely to cause injury, you can repeat this process. Right? You can't do that in the first case. If you're removing under the disciplinary procedures. But if you're asking the hearing officer to order an IAS on the grounds that keeping them in their placement is going to likely result in injury, you can go back and in theory keep asking for it. Okay, so that's I think that's my time. Jeff, we're going to take a break.
We have one question.
Okay.
We're gonna skip the break and we're going straight through. We're gonna power through. We want to prioritize getting out at 11:30, but we have a question.
Yeah, so if you are in a situation where you're kind of struggling with finding a placement, it seems like it would be a lot easier for the student to consider instruction or special, like something circumventing this whole process. So it would make more sense to do it this way. I guess, what's the benefit of doing it one way?
Yeah, and again, we're trying to get
So Rosalie, are you saying that instead of initiating due process for an IAES due to dangerousness, putting the child on home instruction instead? Okay, so I think that can be at times an effective strategy. I have had situations, initiating due process against parents is a big deal. It requires board approval, it's a big deal. So I've had situations where the CSE has placed a student on home instruction for whatever reason, pending placement or because parents are uncooperative. Not a good idea. We can't really prove that's a fake, right? But we've exhausted all options. We feel like we have no other choice. And then with a parents initiated due process and a certain pendency or state book, which gets the student back into their placement, then we initiate it back and we say, no, we want an IABS for the grounds of dangerousness. That's a really intense last resort situation, but it's been pretty effective.
We're gonna skip the break, Kate. Yeah, here you go. And can I just say one thing? Just, if you don't know Kate Reed, Kate is the co-leader of our statewide school law practice. So we're very lucky and fortunate to have her come today. So thank you, Kate.
So much for inviting me, Jeff. It's great to be here. Wonderful to be joining you folks and meeting so many wonderful special ed directors from around the state. So exciting to be here with my partners from Buffalo and Rochester that I don't get to actually see in the flesh every day. So that's awesome. I have the easiest segment to talk to you about today because we have no answers whatsoever. This is an area that is very much in flux right now, which if you've been paying attention to the news, you're likely aware. So we've had significant changes. Hold on, I need a clicker. Where's the clicker?
I got you.
Thank you, Andrew. All right. So if you've been paying attention to the news, you know that there's been significant changes in the United States Department of Education under the current leadership of the federal administration. So significant, actually, before we get into the changes, let's just give a very brief overview of what OCR is and their jurisdiction. OCR was created as part of a comprehensive federal civil rights agenda during the early 1970s to enforce certain civil rights laws at the federal level. The ones that pertain to the folks in this room, we're not going to talk about the Boy Scouts and all of that because that's irrelevant to you guys. The ones that matter to you, OCR has jurisdiction of enforcement over Title VI of the Civil Rights Act. That is a law that prohibits anyone who receives federal funding from discriminating on the basis of race. They're also charged with the enforcement of Title IX, which is the anti-sex discrimination statute, and probably most pertinent to you folks, the Section 504 of the Rehabilitation Act of 1973. So OCR has sole and exclusive enforcement jurisdiction over certain laws, and then companion jurisdiction with the Department of Justice over others. Technically, the Department of Justice can investigate Section 504 violations as well. We don't tend to see that as frequently, and their jurisdiction's more discretionary, so they don't tend to get involved as frequently. So they're charged with the enforcement of those laws. And what that means is that their enforcement team can conduct audits, investigations, and then one of their other big functions that you're all probably familiar with is the annual civil rights reporting as well, that you've had to report. So there's been significant changes. The department has been substantially downsized since the first week of March. And this is really happening in real time right now, folks. I mean, I'll share a little anecdote from my practice. First week of March, I'm responding to an Office for Civil Rights complaint that was initiated against one of my districts in December. I called the investigator at Office for Civil Rights first week of March and say, hey, you're somebody I've worked with over the years. Let's have a discussion about how we can get this case resolved. And he says, that's great, Kate. Let's have a conversation. I'll put something on the calendar. Next morning, I get this individual no longer works for the department notice. So most of the secretaries that have been charged with the enforcement of Section 504 have been furloughed or their positions have been abolished. On March 12th, the Boston, Chicago, Cleveland, Dallas, New York, Philadelphia, and San Francisco regional offices were shut down summarily. There were several injunction requests to try to prevent the understaffing of those departments, and so far those efforts have not been successful. January 2025, and almost immediately following the inauguration, there was an announcement that OCR would be investigating Denver public schools regarding gender neutral bathrooms. So this is probably something you've seen in the news, but this is now the new focus, right, for this this generation of OCR. Right? They're very focused on enforcing Title IX, the sex discrimination statutes, in a manner to restrict the rights of transgender students. That's one of their major policy agendas. And I have to ask, a lot of us have made jokes about this internally, but we're not sure how they're going to do this enforcement activity that they say they're going to carry out, because they've fired all the attorneys and investigators who have traditionally been tasked with doing that work. So who knows how much activity there's even going to be out of this office. Now, February 2025, OCR also publicized that they were initiating investigation into the state of Maine. I come from the state of Maine, so this one's personal to me. The governor of Maine said that the state of Maine would not be backing off their accommodation of transgender athletes on their school teams of choice. Trump administration directed the Office for Civil Rights to initiate an investigation. Also, April 2025, the OCR issued a Dear Colleague letter, which you're all probably familiar with these, and I like to say they have a very friendly title, Dear Colleague, and then they're not terribly friendly when you read the initial letter. But they issued a Dear Colleague in April that essentially said that the focus of this administration, OCR, is going to be on ensuring that any practices in school districts, in K-12 school districts, do not utilize illegal DEI hiring and selection policies. What do you need to know about this? Basically, the brass tacks is the stuff that was illegal in December is still illegal today, right? It is illegal for school districts or other recipients of federal funds to use race or national origin in determining what benefits will go to particular students, how suspension policies are implemented, or how services are distributed. There's really nothing different about the state of the law right now. There's simply a different focus on the part of this Office for Civil Rights. We have not seen any investigations actively undertaken under this DCL yet. I haven't. I don't know if you have, Ann. Anybody over here? So it remains to be seen how this is going to be implemented, but we do expect there will be some enforcement activity. Again, how much, given that they fired all their folks, remains to be seen. So the other big change on the horizon is that OCR's Bible, so to speak, for their own operations is the OCR Case Processing Manual. And because it's their own case management manual, OCR can unilaterally change that manual without any act of Congress or formal regulatory change or anything like that. So shortly after the administration switched, the 2022 case processing manual was repealed. A new case processing manual was drafted. And there's some significant changes in the operating procedure that OCR is going to be using. So one of them is the concept that they don't even have to have a complaint to initiate an enforcement and investigation activity. Now, given the reduced workforce that they're working with right now, we expect that that authority is going to be utilized more broadly than it has in the past, right? Where OCR is potentially going to be working on things like anonymous tips, tip-off, et cetera, where that will be sufficient to initiate an investigation and an insistence on compliance activity. So we may see more directed compliance reviews. And furthermore, OCR has indicated, again, consistent with its reduced staffing, that it's going to be looking for voluntary compliance, rapid resolution, and the use of mediation in order to bring some of these cases to closure. One of the areas where I practice the most in the OCR realm, and I'm guessing my partners will share this, is in 504 compliance complaints, and all of you have probably had the unfortunate opportunity to go through a 504 compliance review with OCR. And it can be, those are very frustrating for most of our clients because there's a level of micromanagement, right, in those reviews that was really, really challenging to deal with. I'm not big for making bets in this political climate because hard to predict what's going to happen, but I would predict that we're going to see a lot less of those 504 compliance audits and investigations, simply because it's not a priority of this administration. The two priorities, as I said, eliminating or reducing transgender accommodation is a huge priority. And then the second is essentially eliminating DEI practices that this administration contends violates Title VI. We don't see anything in these materials recently published by OCR that indicates that they have much interest in 504 enforcement. I don't know about my partners, but I currently have 3 OCR 504 related compliance complaints that were pending before the inauguration. What's going to happen to those complaints? Who knows? I haven't heard from anybody about them, and the primary attorneys who are handling them prior to January have been fired. So I'm not sure what's going to happen with pending complaints. I'm expecting that if the department re-engages with them, that there will be an effort to get them wrapped up pretty efficiently, because again, it's just not a policy priority of the administration. So that's what's going on at OCR. Department of Justice, as I said, continues to have some concurrent jurisdiction over some of these laws as well, not Title IX, but definitely 504 and the ADA. And we have seen some involvement still with DOJ around the enforcement of those laws as well. So without further ado, we pass it over to Jeff. You have a wonderful audience. Thank you so much. Here we go.
Thank you. Thank you, Kate. All right. Yeah, exactly. Thank you. So ironically, it's kind of ironic. So we're here to talk about accommodations in sports. But if you really think about it, what Kate just said, a lot of these complaints go to OCR. So one, if these complaints are brought, will they actually be, processed? But from a practical standpoint, remember, the law is fluid, the law is malleable. If OCR is not going to investigate, there's courts, there's a State Division of Human Rights in New York as well. So we're actually seeing an increase in claims on the state level. So so it's important we know the substance of the law, because there are multiple venues or vehicles through which a parent may pursue a claim. So we're talking about sports today, but just remember that the principles and concepts we're going to discuss apply to any school-sponsored activity. We could do one of these on field trips. We could do one of these on other extracurricular activities. The concepts are the same. So we start with federal regulations. This is essentially the 504 regulations. Students with disabilities are entitled to reasonable accommodations to enable them to participate in school-related activities, including school-sponsored activities and field trips. Anything related to a school, whether it's during the school day or after hours, the student's entitled to accommodation. I'm surprised that everybody does not know this. I get questions a lot. Well, it's voluntary. It's after school. They don't have to go. It's their choice. Doesn't matter. If it's related to the school, then you have a duty to accommodate. And if you're not willing or able financially to provide accommodations during these activities, then you should take that into account when you decide to do that. Because I have any solution to say, well, we won't give the accommodation if it's reasonable. So let's talk about sports. What's important about sports activities is there are different scenarios. In general, there are 2 general categories. competitive activities where you actually compete to make the team, to be eligible, I mean, similar to make the school play, to get the lead, versus activities that are open to everybody, the open gym. So there are some concepts for open gym night on a Saturday night versus varsity hockey tryouts. Different rules apply. So we're going to talk about them. So many school-sponsored events are generally open to all students without tryout or eligibility requirements. Like someone like me, I didn't make, my high school had 4,000 kids. I like when my son's friends, my kids, did you play sports in high school? I go, there were 4,000 kids. I was lucky I was lucky to play in gym class, much less, on the team. But there are lots of intramurals, open gym nights. These type of activities are open to everybody. So there is some standard for participation in these events. It's are they able to meet the essential requirements of the activities with or without reasonable accommodations? That's a fancy word for saying, can we get this child to participate, not disturb the process, not interfere with others, but get them to participate and not alter the activity, but can we get them to play? And and there's lots of scenarios. You have a behavioral student, might need an aide. You might have a student that needs assistive technology. So there's lots of scenarios. So that's what we look at. And it's, you have to look at these on a case by case basis. So here we have a OCR 2008. We had a complaint. This district had a wiffle ball club. This was not varsity wiffle ball. This was a wiffle ball club. Come on down and participate. Let's have some fun. Hit that wiffle ball. This is good time. It's got the old yellow bat. Got that cool ball. Let's go. Anybody want to meet me in the parking lot? We could play. It's funny. I was reading a book. Remember Punch Ball? I had never heard of Punch Ball in ages. This is a New York City game. So I'm sure in New York City they're playing Punch Ball. So wiffle ball. You had a student who was told, you can't play. You had a disability. They were worried the student's physical disabilities would make it dangerous for him to participate. The student, the district was asked the parents to get a doctor's note clearing the student to play. Now, this sounds pretty generic. What's the big deal? They asked the kid for a doctor's note. But it showed you're not allowed to unilaterally conclude you're because of your disability, you're unsafe, you can't play. You have to do an individual assessment of whether or not a child is physically unable to play. And they ordered, to get a doctor's note or doctor's examination. The doctor cleared the student, was able to play. But again, it means it's theoretically possible to exclude someone from an open event if they cannot safely participate. So if the doctor came back and said, you can't participate, it's unsafe, the district would have grounds to exclude. So there are times when you can exclude from open events. But again, in other times, if there are accommodations that could do it, we talk about medical clinics is one thing, but accommodations to enable a student to participate, that's something else. So for instance, a student with behavioral needs may be provided a personal aid during open gym night. And if that's doable, if that's and if that aid would prevent the student from running, from fleeing, from disturbing others, if that would do the trick, then we're obligated to do it. And these type of determinations ideally are done through the CSE or 504 Now I'm going to tell you that if you're going to solve the problem and everyone's happy, you really don't need a CSE or 504 meeting. If you're going to say, no, you can't do this, you need to do that at a CSE or 504 meeting. That includes field trips, activities and so on. You want the parent to have the right to meet with a group of experts and doctors, discuss, get input, and make your decision. There's lots of cases where, again, you're a principal, you don't want to be the one saying you can't go on the trip because of your disability. Let the CSE do that. Okay. Now, again, we talked about on the flip, we don't want to alter the activity. So if it's open gym night and you can give a personal aid to hang out with the student, help the student, assist the student through the process, that's fine. On the other hand, there was an OCR decision, and I think this was advisory, and they said they wanted somebody, the parents of a student with a disability, asked to add an extra base on the field where the student could stay. And that's fundamentally altering the activity. So there is a point where you have to say no, so you don't want to alter the activity, even if it's an open gym night, even if it's wiffle ball night. It's how do we get them to participate on that one activity? Okay, so let's talk about competitive sports. Different story. I think this is an issue where most schools are completely ignoring, just keeping it real. Because a student with a disability has the right to try out for the team. Now, there are certain criteria for making the team, and that student should be subject to that criteria. They don't get extra points because they're disabled. You figure out, though, is there an accommodation that can be given to the student during the tryout that will not alter the activity? The thing is, how does a coach know that the student has an IEP or 504 to even consider if an accommodation is needed during that process? I don't think it happens. A good parent who's knowledgeable could bring it up. If you are a CSD chair or a 504 chair, good idea at a meeting to say, what do you got coming up this year? You've got, you're going to do the play, or you're going to try out for the team. Try to think in advance and anticipate, is there an accommodation needed during a tryout process or so on? But again, we're not altering the activity, we're not altering the tryout practice. So we have a good case in 2013, a student with Asperger's syndrome and anxiety tried out for the hockey team, 16 spots on the team. Student was entering his senior year. He did great on JV, but he was one of 28 students who tried out. He did not make the team. What happened? So the parent was said, this is discrimination. You scored me low because you knew I had a disability. Ultimately, the district prevailed in this situation. So there was no evidence that the student was not selected because of his disabilities. You don't want, that's why you don't want a coach to say, I know you have, now you can say it's better that they don't know because they can't discriminate against them, but you also can't accommodate. So it's like 6 of one, half dozen of the other. The decision to still not select the student was unanimous. Like none of the coaches supported putting the student on the team. And they also noted, so this is more of a discrimination angle instead of an accommodation angle. OCR noted that there were other students with disabilities on the team. 27 students failed to make the team, and there was a student with Asperger's syndrome on the team as well. So, I mean, what you make out of this one is here's a case where they say you must have not picked me because of my disability. What's important here is to the extent that coaches have objective criteria on which they're making their decision, that's great, because it's possible they come back and say, why didn't you pick Johnny? And it would be great for the coach to articulate a reason with objective criteria. I know it doesn't always go out that way. They don't go, you have a 6 of 10 for dribbling in basketball, 7 of 10 for shooting, or so on. It doesn't work that way, but we could be called upon to explain why we didn't pick a student with a disability. You want to have objective criteria. Next is, okay, this case is dealing with a swimmer, high school swimmer, so it's competitive to make the team. There are requirements to participate. This student had anxiety and a fear of drowning. And so this, from the parents, I'm sitting at the dinner table going, how about basketball? Okay, so, but for some reason, they're going on the swim team. And they made the swim team. Must be a good swimmer at school. And the student had such fear of anxiety from going in a pool that she missed practices and she missed swim meets. And ultimately, she quit the team because the coach was saying, look, you really need to be in the pool. You need to be practicing. So this went to a federal lawsuit and the case was dismissed. But ultimately, it gets down to failure to accommodate. Did the district do something wrong here? Should they have accommodated the student's disability? The answer was no. You don't. To accommodate this student, we would have had to alter the requirements to participate, altered the requirements to practice and get in the pool, come to the meets, and swim every day during practice. By excluding the student, that would fundamentally alter the activity. Now, if there was a way to accommodate the student to get her in the pool, then that's what we should have done. Would a personal aid have helped? If a personal aid could have somehow got the student in there, then we should have done it. If there was a behavior plan that would have successfully got the student in the pool, we should have followed it. But they just said, I don't want to do any of this. That's an exclusion. That's a modification that goes beyond our obligations under 504. Let's see. Now, here's another interesting case where the accommodations would give the student an advantage, and that's not fair either. So you had a student played football, and the student had some physical issues and needed abdominal padding, which exceeded what the typical player could wear, needed an internal heat monitor and direct medical supervision because the student suffered from physical ailments and heat stroke. The court ruled that that's too much of a fundamental alteration. Now, a monitor in itself probably would have been okay. Medical treatment on the sidelines, that's probably okay. I think when you need padding that would give you an advantage, you could take a hit that someone else would have to suffer from, that gives you an advantage. And so that is how, so these have to be broken down on a case-by-case basis. The object here is what can we do without altering the activity to get you to show off your skills and see if you can make the team. Okay, here's another one. You had a basketball player. See, this we shouldn't see this anymore. Obviously, we shouldn't see this. Yeah, a student with diabetes who played basketball, and this student just wanted to self-check his blood sugar during practices and said, "Coach, can I just step aside and check?" The coach said no. And so OCR said, being able to check one's sugar levels was a reasonable accommodation that did not fundamentally alter the activity. If the student's able to do everything else, and you see it all the time. You see sometimes kids or adults, putting insulin in on the bench. That's okay. That's a reasonable accommodation. Now they can't run around with a doctor on the court next to them at all times. That's altering it. So there's a time where the district, fell short. That's why you're going to see as an accommodation, nurses. Remember, some kids, that's an interesting point. The accommodations you get in school may differ from what you get in the activity. Think about it. If you need to be within proximity of a nurse. You need a nurse to come to you within 5 minutes. A school nurse is fine. You don't need a personal nurse. But if you are going on a bus that's an hour ride, you might need a nurse with you on the bus. You might need a nurse with you at the game. So it all is fact specific. And ideally, the CSD is dealing with this in advance as opposed to the day of the game. I always make this joke. I get the phone call that you must have heard this 100. Andrew's heard this so many times. He could probably tell a joke. I get the call, the field trip. Hey, Jeff, can I take this student on the trip? Here's the situation. And I go, I can't hear you. What's that noise? And go, oh, that's the bus. Like they're getting on the bus right now. And we're like, hold on, we need some time to work through these in advance. Okay, unfair advantage. You can't use this to give yourself an advantage. It could level the playing field, give you an opportunity to participate, but you have to look at circumstances and say, are there ways in which a student's getting an advantage? OCR wrote this great, thorough Dear Colleague letter about 12 years ago, and they gave all these examples about, okay, you could have a student in a track and field event who can't hear when the gun goes off, but could see. So they asked for a flick, like someone to flash a light, and that was deemed okay. But I guess if you really break it down, imagine if it's a short race and someone says, well, it's a nanosecond quicker that way, maybe it is an advantage. Who knows? That you could have examples about a student with one arm and it's doing a swim meet, and the rule is you have to touch the wall and a lap with two arms. What do you do in that situation? Is it okay to just use one? And they have to assess is does doing it one way with one arm give you an advantage or not? And they have you could have experts testifying and looking into this. Pretty interesting stuff. Eligibility requirements. This is important. The eligibility requirements apply to students with or without disabilities. So if it says in your policy you must be passing all your classes to participate in varsity sports, that applies to kids with or without IEPs. The student with an IEP can't say, hey, I have an IEP, I shouldn't be subject to that. Yes, you are. The only way to get around that is if the student parent says they need to participate in an activity for a FAPE. You should never put that in an IEP. That's just not going to happen. Or probably not. So let's see. Failure to notify equates to exclusion. Don't forget for sports, if you're notifying kids that tryouts are next week, you got to notify. You need to notify everyone, even the kids with disabilities. Even you might say, why would I send an email to the kids in the 611 class? Because you have to. And if you don't notify everybody, that's viewed as exclusion. Okay. Here is another situation. Okay, here we go. The last case. By the way, this is from Colorado. It says Brighton School District. This is Colorado. This is not Brighton down the block. Just saying. Someone might say, "Oh my gosh, that's we know them." No. So okay. No, it's not. It's in Colorado. So it's a these cases are rare. You don't get a lot of sports cases, and this one just came up. Federal District Court in Colorado. Basically, a student with autism and sued the district and said it was a female student, and she said that the coach refused to implement her IEP during basketball practices and games. Here's some of the facts. The student had a number of significant learning disorders. She struggled to complete tasks and understand directions. She needed her work assignments to be chunked into small pieces, and she made the varsity basketball team in her senior year. The coach refused to play her in games, claiming she could not remember the plays. So the coach is saying, hey, I'm applying the rules equally. We need you to follow the plays. You're not following them. And the student said, well, if you followed my IEP and you delivered the plays to me in a manner in which I could understand, I would be able to do it. And the coach refused to do it. And this is where, remember, like he makes a derogatory comment about students with disabilities. So really not a good idea to make that. So that really colors the whole thing. But so basically though, the student is saying, if you accommodate me by explaining the plays in a certain way, I could do this. And ultimately, so here's the thing. There's a lot of legal stuff in this decision. And the district tried to move to dismiss on multiple grounds, and none of those grounds were successful. So the case is still pending. The court didn't expressly rule if this is a reasonable accommodation or not. That's coming, maybe a future presentation. We'll do a follow-up. But what it shows is these concepts absolutely apply in varsity sports. And there is a burden to accommodate without altering the activity. And this court is going to have to figure out if this is a fundamental alteration of the activity. Now, again, I'm guessing if they could show that the teaching took place in advance and that would get the student to participate, they'd be in good shape. The parent would be in good shape. If the district shows that this teaching was ongoing and during games and things change and I need people to alter the plays without advance notice, the district could win. It depends. But this case, though, the fact is the court didn't dismiss it and say this is all inapplicable. It is. So we found it very interesting. Again, also, this district also said, this is a coach, not an employee. This isn't like a teacher, it's just a coach. So we shouldn't, the duty to accommodate doesn't apply. And that was a ridiculous argument, which was quickly dismissed. But again, it shows that coaches should be aware of instances when accommodations are necessary. And, although not expressly addressed in this decision, it underscores the need for the CSD and 504 team to look at this in advance, anticipate these things, and deal with them in the proper setting, one way or the other. Because again, it is possible the CSD meets, 504 team meets, considers everything, and says, we can't make this work. We cannot accommodate you. And that's okay, again, if it's accurate, but you have to do that, make that decision at a 504 or CSC meeting. All right, that's it for me. Thank you, everybody, for coming down for our program. Have a wonderful summer. We hope to probably do like another webinar over the summer. You can't get enough of this information. So we love to stay in front of you. We'll get some great programming in the fall. Thank you, everybody. Safe travels. Have a great day.